Onto this story now. Job cuts are on the rise in the country. Now, if you're a member of a majority union, you have little or no say in the retrenchment agreement. The Constitutional Court has made a ruling allowing for a majority union to finalise retrenchment agreements with employers. Now, the agreement will be binding to everyone, even if minority unions and their members have not been consulted. For more on this, I'm joined by Labour lawyer Jonathan Goldberg. He is joining us via Skype from East London, and he's with the Global Business Solutions Group. Mr. Goldberg, thank you very much for your time. So, I just want to quote what you said on the back of this judgment at the Constitutional Court. You said, "Retrenchments are not based on individual conduct. Therefore, there's no need for individual consultation." Does that make for a harmonious working environment, though?
Good morning to you and your viewers. The Constitutional Court has now confirmed what we thought was the interpretation of the Labour Relations Act. And that really is, in this case, where NUM had 75% of the representativity members. They did an agreement with NUM, and that agreement allowed them only to consult in retrenchment dismissals with NUM and UASA, who were party to that agreement. Remember, in this case, 75% of the members belong to NUM, and effectively, the Constitutional Court has ruled that if you consult with the majority trade union, like in this case, then that agreement, if extended properly in terms of Section 23(1)(d), is then applicable to minority trade union members as well as to non-union members. And we took the decision in 1995 collectively as a nation that majoritarianism is the way to go, because the converse would be absurdities in terms of consulting with every single individual. So our Labour Relations Act is founded on the basis that you can negotiate with the majority trade union, not only on retrenchments. This case was specifically about operational requirement dismissals, but about wages and conditions of employment, and extend that and bind the non-union or minority unions in regard to those agreements. So this Constitutional Court just confirms what the Labour Court said and the Labour Appeal Court, both in this decision and a long line of other decisions.
So the majority union, as you explain, essentially takes or makes a decision on behalf of every worker in the workplace. I put it to you, therefore, that precipitates, or that could possibly precipitate, another Marikana. Am I being alarmist?
Well, I think in 2015 and in 2019, amendments were made to the Labour Relations Act to stop another Marikana. In other words, to allow a whole range of opportunities for minority unions to come into the workplace, specifically in regard to stop order deductions and access to their particular members. But you also can't have a situation where every single minority, I've got 1% of the workforce and I've got bargaining rights and negotiating rights equal to majority trade unions. It's quite interesting. One reads the majority judgment here. The majority judgment indicates, and that's correct, this is in line with international principles, international labour laws, and other international best practices. The minority decision in this case, and there are two minority decisions by two judges, and the majority point out that even if you concluded this agreement could still be subject to challenge. When you extend the agreement, it could still be subject to a review. And in my opinion, and I accept that lawyers would be split on this, in my opinion, if the retrenchment was procedurally or substantively unfair, people would still have the right to challenge that dismissal. Let me give you an example. So in this case, NUM was the majority trade union. If they had concluded an agreement that their members would not be retrenched, because in retrenchments you need to find an objective criteria, then that decision would be discriminatory against other, like AMCU members and other non-members. So that would be challengeable, and a court would overturn that. So it's incorrect to think that this is the end of the story. If that agreement is unfair in any way or discriminatory, that agreement would be subject to legal challenge.
Final question to you, Mr. Goldberg. As we all know, the appeal was dismissed by the majority judgment. The question, therefore, is there recourse for those who feel that Section 189, subsection 1 of the Labour Relations Act is in violation of the Constitution because it does not guarantee fair labour practices?
Well, this challenge was specifically on that, and I always keep on saying after the Constitutional Court, we'll have to wait a long time till you go to heaven one day before your next judgment day. But that's the end of the matter in respect to the challenge on Section 23 of the Constitution. So that's a finality as to whether 189 and this particular majority clause contravenes Section 23 of the Constitution, the right to fair labour practice, as you quite correctly put it.
All right. Thank you very much for your insights there. Jonathan Goldberg, he is with Global Business Solutions on this judgment by the Constitutional Court.